Hello everyone, this is Tom Fox. I'd like to welcome you to a special Thursday night edition of This Week in FCPA for the week ending July 15th, 2016. Together with my co-host Jay Rosen, we review the week's comings and goings in the FCPA. In this episode, we talk about the Johnson Controls declination, which is the third declination of the year. Also, we talk about the FCPA pilot program and how the Department of Justice is certainly going full bore to publicize the benefits of companies who fall within the prescriptions of the pilot program. We talk about some of the facts of the Johnson Controls enforcement action and how they may have gotten in trouble for some of the failures of their internal controls. We talk about the second deferred prosecution agreement from the Serious Fraud Office in the United Kingdom. We talk about the new SEC disclosure rules regarding extractive minerals and how they could raise FCPA concerns for energy companies. Jay touches on the movement of former federal prosecutor Paul Pelletier to Pepper Hamilton, and we conclude with some remarks about our upcoming summer travel schedule. So I hope you enjoy this week, and thank you very much for listening. Hello, everyone. This is Tom Fox. I'd like to welcome you to this episode of, This Week in FCPA. I'm doing too many podcasts this week. For the week ending July 15th. And you will note this is not July 15th. It is July 14th. And so this is a special Thursday night edition of This Week in FCPA, presaging, portending, and all things honoring Tom Brady today. Because, of course, he lost his appeal to the Second Circuit Court of Appeals for a hearing en banc, and he is now facing the possibility of not seeing his wife, but not seeing the football field for the first four games. So, Jay Rosen, how are you feeling today?
I wish we would be talking about the weather instead of Mr. Brady, but I think as many of the Chowderhead pundits have been saying is I think he needs to worry about the team now. If they can get through the first four games 2-2, they should be able to move forward. The East is still theirs to take. So I would say that now's the time for him to acquiesce to Commissioner Goodell, not Roger.
Well, it's a 105-degree heat index here today in lovely Houston, Texas, so it can't be any worse where you are. Obviously hot there with the news of Tom Brady. Nevertheless, we've had a very interesting week in FCPA, Jay. You want to start us off with your highlight?
I think one of the things we were commenting last week that it was very slow in the FCPA world. And yes. DOJ came out with a bang announcing the Johnson Controls declination. And, this is now the third one in I would still consider it the first half of the year. And a couple of things that I found interesting about it is that this is another matter that Wilmer Hale worked on. They also worked on the analogic matter. And there's also one attorney who was involved on both of those, Jay Holtmeyer, and he got both his declinations on the same day, June 21st. So it must be kind of a cool feeling to get two declinations for clients in one day, considering there's only been 3 declinations so far under the new pilot program. So that's my, initial off the top thing. But I think you wanted to talk about some happenings overseas on the other side of the pond. And then maybe we can kind of compare and contrast the differences between a DPA under UK law and what we're seeing now under the pilot program here in the U.S.
Well, Jay, before we get there, I think the JCI or Johnson Controls enforcement action was quite interesting for a number of reasons. First, as you didn't allude to, you actually said this was the third declination publicly announced this year. We've never had a year where 3 were publicly announced. There have been years where there have been more than 3, but they are not publicly announced. The information is given to the company by the Department of Justice, and the company may do with it what it deems fit. Nevertheless, pretty significant. The DOJ is certainly trying to drive attention and traffic to its pilot program. We've had four enforcement actions since the implementation of the pilot program. And in the fourth enforcement action, the company secured a non-prosecution agreement, which is almost as good as a declination. So the department is clearly communicating that if you follow the prescripts of the pilot program, which are self-disclosure, cooperation during the pendency of the investigation, and extensive remediation, and profit disgorgement, you can receive a healthy penalty from the Department of Justice. And 3 out of 4 get declinations, and the 4th gets an NPA. That's a pretty good roadmap of where the DOJ is taking this. But I was really interested in some of the background facts. So not that I'm going to geek out, but
break
so
those glasses out.
Yeah, glasses. We're going to the glasses. Johnson Controls actually got this Chinese subsidiary called China Marine via acquisition. So kind of lesson learned one is if you have a acquisition of any business units in China, you need to take a very close look at them. They did that, and they've terminated the employees involved in the acquired company's China Marine business unit. Nevertheless, the next set of employees brought in under JCI's watch continued the bribery scheme. And what I found even more interesting was that the bribery scheme was so sophisticated that Johnson Controls either couldn't, wouldn't, or didn't pick it up. And this was in the face of some pretty strong evidence. So we had bribe payments. I can't remember the amount of bribe payments, but the benefit was $11.8 million. So it's, as I said, I gave a speech today to the Gerber at our annual members only conference. And I said, if you cannot determine how a business unit is making sales, that's not the business unit's problem. That's your problem. If you in the corporate office cannot figure out how folks are making sales, that's a significant failure of internal controls. That's accounting internal controls. That's financial internal controls. And you have got to get a handle on that. So I thought that Johnson Controls engaged in a standard of behavior below the reasonable corporation in terms of their internal controls. So I certainly found the SEC enforcement action appropriate. Nevertheless, a great result on the criminal side. So the DOJ once again is made clear. I had a podcast on the pilot program this week with a fellow named Michael Kelly, a partner at Hogan Lovells in DC, who had some very interesting thoughts on why the DOJ created the pilot program and how they're communicating that going forward. So once again, a very interesting case, interesting week, lots of lessons, important lessons for the compliance practitioner if you drill down into the facts of the case. So, but with that,
2 quick questions.
Sure.
First of all, not that we've seen this movie before, but is there some kind of website that all these fraudsters go to figure out how to overpay themselves and kick back? I mean, how many times have we seen that this year? And if we're seeing that, we're seeing it after the fact, but I think to your point earlier, people should be seeing that if they're doing compliance.
Right. And if you think about the fraud triangle and how fraud occurs, the specific methods of the fraud scheme vary, and they're going to vary from company to company, but its method means an opportunity. And if you have an opportunity to do so, if you think about the 3 prongs of an effective compliance program are prevent, detect, and remediate, that's why you have a detect prong. And if in your detection, you can't figure out how your business unit is doing business, or you can't figure out the scheme by which they're rebating monies to third parties to pay bribes, that's on you. You should have more robust controls. And I think that's, a deficiency in accounting controls that are really compliance controls. So even if the fraud scheme varies, and they do vary, you're in many ways fighting the last war, but that's why you have robust internal controls, and that's why you monitor and audit going forward. So the detect prong is extremely important for lots of different reasons.
All right. So that was one. And number 2, right before I raced back on the Hollywood freeway to get here for our 5 o'clock blab, I was having a cup of coffee with an FCPA practitioner from Gibson Dunn. And we were talking about the pilot program, and her question was, well, the pilot program just came into being right now, but we're rewarding behavior that's been investigated for over the last year or two. So it's very hard to actually gauge the effectiveness of the pilot program in this calendar year because on the whole, most FCPA investigations take longer than a year. So is this the DOJ and, as our friend the prof would say, don't believe the hype. Are they taking the hallmarks of what they want to reward within the pilot program, and are they backcasting them on events that have happened already?
If there had never been this situation before, that might be plausible. But the problem with that is, and really what that type of analysis misses, I think, is the Department of Justice has been communicating to us for the past couple of years what type of conduct they will reward in the form of a reduced penalty. And if you think about Parker Drilling, where you had C-suite involvement in the bribery scheme, yet a fine 30% below the minimum suggested under the sentencing guidelines. If you think of Hewlett Packard, which had multiple bribery schemes across three separate countries in multiple continents, you had a complete systemic failure of internal controls. You did not have self-disclosure, and indeed in Parker Drilling, you did not have self-disclosure. Nevertheless, HP got a very significant discount as well, I believe 25% below the minimum range of the sentencing guidelines. So the DOJ was clearly communicating that they would reward behavior consisting of extensive cooperation in the investigation and extensive remediation during the pendency of the enforcement action. What they have added is this additional credit for self-disclosure. If you think back to the Ralph Lauren enforcement action, where Ralph Lauren got an NPA and they were rolling out their compliance program. So the people I talked to said we didn't feel like we could give them a declination because they hadn't implemented a compliance program. They determined the bribery occurred in the rollout, and that's when they got wind of it. So I think the DOJ has been signaling this, but the pilot program really crystallized it in everyone's mind. And I think they've taken the opportunity to take these four cases, imprint the reductions on the pilot program. And this is even with, you had a 6-year, I think, investigation and internal investigation and enforcement action. Contrast that with Akame and Nortec, which were less than 18 months. So we've had very long time periods of investigation, and we've had very short time periods of investigation. So the pilot program may have crystallized what the DOJ's thinking was. It certainly communicated in writing to you and I and the others in the compliance field what they were going to give credit for. And now I think they're rewarding people who do it.
Great. Well, I appreciate your thoughts on that. So we can go one of two ways now. We could go and do SFO, or we could talk about the new SEC payment disclosure rules as it concerns energy companies in Houston.
Well, let me go to the SFO because that's what I prepared for next.
And okay.
Preparation is the key. In case you didn't know that, that's a freebie from today. So we have the Serious Fraud Office announcing their second DPA. The company was not named, although it was a designated to be a small or medium-sized firm with, quote, U.S. registered parent company, end quote. I found a couple of things interesting in one, and then some points will really speak to the point you raised, is what's the difference in the practices between the two countries. So we had, once again, an unnamed company who paid a total of 6.5 million pounds, which is about 850 million for the settlement. 8 million of that was in disgorgement, and 455,000 is the fine. The U.S. parent paid 2.6 million in disgorgement as well. So it was interesting that this was a self-disclosure to the SFO, which is one of the requirements to get a deferred prosecution agreement in the United Kingdom. And there were 74 contracts examined. 28 were procured with bribery. And So it appeared there was a pervasive bribe scheme going on here. But what I found interesting were the comments that SFO Director David Green made, and his comment was the decision as to whether to force a company into insolvency must be balanced with the level and nature of the cooperation, and this case provides a clear example to cooperators. It was, I think, pretty well known and part of the public record that this company could not sustain a large fine. So clearly the SFO is sensitive to putting this company out of business. That's one of the rationales for deferred prosecution agreements in the United States, so companies didn't go to trial and get Arthur Andersen out of existence. But clearly that is something the SFO considers a plus for deferred prosecution agreements. But then I found this next comments interesting as well, and it noted that, and I'm pulling this article, this quote from the FCPA blog, but the SFO said, a DPA is not a private deal or bargain between a prosecutor and the company. It is a way in which a company accounts for its alleged offending conduct to a criminal court and can have no effect until a judge confirms in open court that the DPA is in the interest of justice and the terms are fair, reasonable, and proportionate. That, to me, Jay, is the most succinct statement of the difference in a DPA in the United States and the DPA in England. In the United States, I would say a DPA is absolutely a deal. It's a deal between the prosecutors and it's a deal between the company. The court does not have the right to look into the terms of that deal. And unfortunately, we know that now because Judge Rakoff attempted to do so. And the Second Circuit said absolute prosecutorial discretion. So a DPA is a deal. It's a negotiated deal. I don't have a problem with a negotiated deal if that's what the parties come to. And the facts stated in a DPA are negotiated. So we're not going to get the full flavor of all the facts known to the government. Obviously, the fine and penalty, there's a sentencing guideline with a range based upon a formula. But the DOJ now, as we now know, that's Department of Justice J, not JJ, has a significant discretion, which they've articulated for us in the pilot program. So, but the explanation of further explanation that the the DPA can have no effect until a judge confirms in open court, that is not a part of the American system. So pretty clear statement on the differences. And I thought that it made an interesting contrast to some of the things that we see, some of the commentary we see, and some of the reasons indeed for deferred prosecution agreements in the United States.
Yeah, I'd agree with that. But they're also, when I was scanning the article, I had certain things that jumped out that were reminiscent of the pilot program. They were rewarded for their cooperation, for a proactive approach, and for making a cultural difference in the company. So, there still are a lot of similarities between once you find the wrongdoing, then what do you do, and then how do you cure and what is the remedy for cure? So, but the judicial angle is very interesting. And has that been? Has anybody tried to bring that to bear to modify the FCPA with that type of judicial oversight in the U.S.?
Yeah, that was my point about Judge Rakoff. He objected to a settlement, not in the FCPA context. I think it was HSBC, but it was around one of the banks. And he found it was insufficient. And both the SEC and the party appealed to the Second Circuit Court of Appeals, and the Second Circuit absolutely slapped down Judge Rakoff and said that he had no authority to review or deny the DPA. It was simply an agreement. The prosecutor had the absolute discretion to bring it. It was a private agreement between the parties, and his sole role was to rubber stamp that. So that's really not a part of the FCPA. That's part of judicial review. And I'm not a criminal procedure expert, but as long as prosecutors have the authority to bring the charges that they deem appropriate, and if a party agrees with those charges, in a signed document, which would then be presented to the court. The court has no authority under U.S. criminal procedure, it appears to me, to object to it or modify the terms.
Okay, got it. What was I going to say? So I guess the judiciary just has to take care of their business, just like certain Supreme Court justices shouldn't say anything about presumptive Republican nominees, correct?
Well, I'm not sure it goes that far, but they don't have the right to talk or rule or opine. So perhaps the analogy is appropriate.
Perhaps. So I thought this one would resonate with you being in Houston, but this is a piece we picked up from a Pillsbury client alert by William Sullivan and his colleagues. And basically it says here back on June 27th that final rules requiring public disclosure, among other things, of certain payments made to foreign governments by resource extraction issuers. And this goes on top of the Securities Act and some Dodd-Frank changes to that. So not that the DOJ and the SEC didn't have a reason before to look in at energy and extractive companies, but now when they're specifically asking them to scrutinize any type of payment that's made to a foreign government, does this increase the fear of the energy industry about doing business, and what would be the appropriate response here to this new law?
So the client alert says that the covered payments that must be reported are broadly defined to include all payments of $100,000 or more in a given fiscal year in furtherance of mineral or resource extraction, including taxes, royalties, fees, production entitlements, bonuses, as well as community and social responsibility payments. So this is a level of disclosure that we have not seen, a mandatory level of disclosure we have not seen before. Frankly, $100,000 is not even a rounding error to most international energy companies. So the materiality standard is, if you can even say materiality, it is so low as to almost be non-existent, probably like about $10 to you and me. So, or at least me. I don't know about prestigious Brentwood or Encino, Encino, where you live. Did you really buy OJ's house, or was that just a rumor?
It's just a rumor.
Just a rumor. Okay. Well, I heard an interview with the mayor today of Los Angeles, and he said whatever rumors you've heard, they're not true. So I'll just take that blanket statement and apply it to those rumors I've heard about you. Nevertheless, this is a lot of information. Say again.
Materiality.
So that's a rumor too. But with the information that's going to be reported, this is going to require companies to give the government a lot more substantive information. And when I first read about this report, I hadn't really thought that the DOJ and SEC would data mine this, although Pillsbury really harps on this. And let me quote from their client alert. Therefore, the DOJ and SEC are expected to use the new disclosure rules as a basis for launching investigations and potentially commencing prosecutions or bringing enforcement actions under the FCPA. I had really disagreed with that statement when I read it, but as you and I talked through the threshold of the amount of reporting as being so relatively low or non-material to a corporation, it may indeed give the government a lot more information, and it may give them a way to cross-check or check in or sort of have oversight in a way they've not done so before. And not that they need any more work, but they have doubled their FCPA unit, and those lawyers are going to need something to do, and they've increased the size of the FBI investigators around white-collar and financial fraud, of which FCPA is a part. So, it could well lead to that, and I think it's going to cause more grief in the energy and extractive space than I had originally thought.
Great. So what else do we have on our list? We're actually moving quite briskly and have about 8 minutes left.
Well, I think you wanted to talk about Paul Pelletier.
Paul Pelletier.
Yeah.
It who has a long and distinguished career in the DOJ, many different positions. Most recently, he was with Mintz Levin, and he's just made the move to Pepper Hamilton. So, we wish him well at his new firm. I've had the opportunity of engaging Paul several times at some of the FCPA conferences, and he's always a good conversation, and he's really written some very thoughtful pieces as of late. So it'll be interesting to see whether Pepper Hamilton provides a different platform from him as opposed to his previous employer over at Mintz Levin.
Well, with the association of Louis Freeh to Pepper Hamilton, it may actually really make an even more robust team. That Pepper Hamilton has had some very high-profile investigations, Penn State, Baylor, some overseas investigations, and so certainly adding someone of Paul's stature to your team can only enhance going forward. So, we've had some very interesting moves. Last week we talked about Pat Stokes to Gibson Dunn, and some really top FCPA investigative talent in negotiating with the government and doing those types of external counsel roles that I think are going to become more important after the Yates memo. So let me just end.
Okay, go ahead. Sorry.
End with this question that was posed to me today. I gave a presentation on legal ethics around internal investigations. And part of it was state bar rules, State Bar of Texas rules, and part of it was what are the implications after the Yates memo. And one of the points I raised was we have now had a chief compliance officer be a successfully rewarded whistleblower under the SEC. We've had general counsels be successful whistleblowers. And the question posed to me was, what happens when a company wants to go after a general counsel or a compliance officer or practitioner who's a lawyer and has an ethical duty not to disclose confidential secrets, client confidentiality? I answered, well, I thought the question had been answered by the SEC, and his response was, which I found valid, well, they don't speak for the state bar. And if the state bar doesn't change its position, that could still be a disbarment event, even if the SEC rewards whistleblower with part of the bounty. So that's a dynamic tension I really hadn't thought through, but that may be present, and state bars are not governed by the SEC nor even the DOJ. They are independent associations, much like the Republican Party. The state of Virginia cannot force a delegate to vote and put him to jail if he votes in a way that the state of Virginia says is not true or not valid. It's a free association. Then the association's rules, the association can make its own rules, and state bars are voluntary associations of attorneys. And so I think we may have to watch that going forward.
That's pretty interesting. So their rulings are only going to affect members of their state bar. You could only legislate what's happening within Texas.
Right. But
Okay.
say a Texas general counsel or a Texas chief compliance officer who was a lawyer disclosed to the SEC or any other government agency, and the company wanted to go after them, they could conceivably file a grievance and take that up with the state bar. So hope it doesn't happen, but well could.
So are you on the road at all next week? Any speaking engagements, travel engagements?
Taking my daughter to see her grandmother.
Oh, wow. How awesome.
Yes.
Road trip or plane?
Overnight trip, day trip. My mom lives about 90 miles away from Houston. My daughter's in town. Freshman just finished her first year at Whitman College in Walla Walla, Washington. So she's down here enjoying our heat. She claims it to be too hot for her. I can't imagine why she'd say that. But so we're going up to see Grandma next week.
All right. Well, next week, Millie and Michaela begin a week of cooking lessons at Sur La Table. So Rebecca and I are seating the kitchen to them, and they will be responsible for cooking dinner every night.
Well, that will be very cool. Nothing better than having your daughter cook for you.
It's awesome. They make a mean chicken schnitzel, and when you come out to LA, we'll definitely treat you to that.
Well, I'm looking forward to it. You guys got any travel for the rest of the summer? Or are you bunkering in at prestigious Encino?
We are just we're off schedule. You know, and the last couple of years they went to day camp, and so
Right.
day camp was like school, but now we've been to sleepover camp, swim camp. So my marketing guru and I are just we're not adjusting. We're taking it day by day, but it's every day is a new adventure. So we're having fun, and
the Disneyland Life Pass yet?
we're off for the summer because we have a limited blackout date. So we won't be back until Disneyland until sometime around Labor Day, I believe.
Okay. Well, I'm sure they're missing.
But they're no, we're still finding other ways to support the mouse. Guaranteed.
Oh, Jay, it's has always been a pleasure, and I look forward to seeing what happens over the next now 8 days, and we'll catch up hopefully on July 22nd.
Great. Have a great weekend. Thanks everyone for watching this week in the FCPA.